This is another video for my professional responsibility class. We're finishing up Rule 1.11, which is conflicts of interest for government lawyers, and special rules that apply when a government lawyer, so let's say a public defender, a district attorney, someone who works for a regulatory agency. Here in Houston, I teach in Houston, Texas. We have a really large city attorney's office of the city attorney, that actually employs a lot of lawyers. And so it could be that you're doing civil litigation or for the city or something like that. And in this video, we're going to focus on the comments to Rule 1.11. A lawyer who has served or is currently serving as a public officer or employee is subject to the rules of professional conduct, including the prohibition against concurrent conflicts of interest stated in Rule 1.7. In other words, you are not above the law or above the ethics rules just because you're a government lawyer. The ethics rules apply to government lawyers too. In addition, such a lawyer may be subject to statutes and government regulations regarding conflicts of interest. Very common in federal and state law that there's a body of law, there's statutes about conflicts for not just lawyers, but government employees in general, about gifts that you're allowed to receive from private parties and so forth, and employment that you can do after you leave government service and so forth. So not only are you bound by the ethics rules, legal disciplinary rules or ethics rules of your state, but there also could be, very likely, are statutory rules about government employee conflicts of interest, anti-bribery statutes, and things like that that will also apply to you. These statutes and regulations may circumscribe the extent to which the government agency may give consent under this rule. So even if there's something that the rule would allow the government to consent to, sometimes they will be bound by a statute or regulation, and so they can't anyways. Paragraphs A1, A2, and D1 restate the obligations of an individual lawyer who has served or is currently serving as an officer or employee of the government toward a former government or private client. And so, by the way, notice something. When I was talking normally, and I did this when I did the video on the rule for 1.11, we're mostly thinking about lawyers who go from a private firm job to working as a government lawyer. But it could, or in my own experience, I went from working for a legal aid clinic to working for as the state attorney general's office in Connecticut for a while before I became a professor. On the other hand, it could be that you are migrating from one government law office to another. So let's say you go from the state attorney general's office to the U.S. attorney's office, or to the city attorney's office in a large urban area or something like that. Rule 1.10 is not applicable to this rule. And why? Don't be confused. 1.11 basically restates everything that's in 1.10 it adapted a little bit for the government lawyer context. Okay. B sets forth a special imputation rule for former government lawyers that provides for screening and notice. Because of the special problems raised by imputation within a government agency, paragraph D does not impute the conflicts of a lawyer currently serving as an officer or employee of the government to other associated government or officers or employees. Watch out, that could be a gotcha question on the MPRE. When you leave government service and go to the private sector, your conflict of interest, like nobody at your firm is allowed to work on a case that you were working on as a government lawyer unless we screen you. We have screening in place to isolate you from divulging any information or getting any information about the case. In contrast, if you go to, if you are going if you're working for the government still, and you're working on a matter, there's a matter that you worked on in the private sector, you can't work on it, but we're not going to impute the conflict to everybody else in your office. So we don't really apply the imputation to government law offices. Even so, it ordinarily will be prudent to screen such lawyers. Comment 3. Paragraphs A2 and D2 apply regardless of whether a lawyer is adverse to a former client, and are thus designed not only to protect the former client, but also to prevent the lawyer from exploiting public office for the advantage of another client. For example, a lawyer who has pursued a claim on behalf of the government may not pursue the same claim on behalf of a later private client after the lawyer has left government service, except when authorized to do so by the government agency under paragraph D. And so I'm going to give two quick examples. You may know that a lot of our federal environmental statutes, and probably some of our state statutes too, have also create a cause of action for citizens, for private parties, either to sue each other in the place of the state, or to bring a citizen suit when the state hasn't brought an enforcement action. And so, for example, under the Superfund, the CERCLA laws, parties who have if you have a group of adjacent properties that have all been polluted by one polluter, not only can the government bring an action for a cleanup, but everybody who has to clean up their property can sue the same party for reimbursement for their cleanup costs, sue the polluter. And so that's a common example. And so what you can't do is bring the enforcement action, then go to a private firm and represent the neighbors, let's say, who are also suing the polluter. Similarly, a lawyer who has pursued a claim on behalf of a private client may not pursue the same claim on behalf of the government, except when authorized to do so by paragraph D. Comment 4. This rule represents a balancing of interests. On the one hand, where the clients are a government agency and another client, private or public, the risk exists that the power vested in that agency might be used for the special benefit of the other client. And so we recognize that there's a power imbalance, and what we don't want is someone exploiting the fact that let's say that a government agency has also been going after your opposing party in litigation. Continuing, a lawyer should not be in a position where benefit to the other client might affect performance of the lawyer's professional functions on behalf of the government. Also, unfair advantage could accrue to the other client by reason of access to confidential government information about the client's adversary obtainable only through the lawyer's government service, and that's not right. Comment 4 continues. On the other hand, the rules governing lawyers presently or formerly employed by a government agency should not be so restrictive as to inhibit transfer of employment to and from the government. The government has a legitimate need to attract qualified lawyers as well as to maintain high ethical standards. Thus, a former government lawyer is disqualified only from particular matters in which the lawyer participated personally and substantially. So I want to focus on that last part because that's the takeaway for exam questions. So let's say that you did tax enforcement for the Treasury Department as a government lawyer. Well, those cases can go on for a long time. And so let's say you were working on an investigation in the early stages of filing an enforcement action against someone for tax fraud, and then you leave and you go to a private sector job. You can't work on that same case, either representing the person who's being audited, let's say, or charged with tax fraud, or someone else who is doing a very closely related claim about the tax fraud. And but can you leave the Treasury Department and go represent taxpayers against the IRS or Treasury for the rest of your career, and have your former employee, that agency, as the adverse party in all of those cases? Yes, yes, yes. And so watch out for that on exam questions. If you leave a government, so I worked doing environmental enforcement before I became a law professor, and pretty common if people leave that job that they go and they do environmental work in the private sector. And guess what? If you do environmental work in the private sector, you're usually defending polluters. So it's not uncommon that somebody who used to work in the very government office that's now the opposing party is representing the people who are the targets of enforcement actions. That's okay as long as it's not one of your cases, as long as it's not the same case that you worked on. Also, now I want to talk about this policy judgment. On the one hand, we have to have some rules to keep people from abusing their position in government and the access to information and things like that that they have. On the other hand, we don't want a situation where you really can't leave government service once you take the job, right? Because of conflicts of, if you're conflicted out of everything and stuff like that. So if we made a strict rule that once you're a government lawyer, you can't ever work in the private sector as a lawyer, then the government would have trouble attracting high quality lawyers. And instead, it would only get the lawyers who can't get a job anywhere else. And so the taxpayers would only have lawyers without a lot of marketable competence, let's say, working for them. And what we want is we want the taxpayers to have good lawyers on their side working for the government too. And so we created this rule before we even created 1.10 and some of the other conflicts rules, so that people, especially right after law school, maybe could go and work for the government for a while and then go to the private sector, or could work for the private sector, go to the government for a few years, and then go back to the private sector. And we want to facilitate that movement so that we can have high quality lawyers working in the government. The provisions for screening and waiver in paragraph B are necessary to prevent the disqualification rule from imposing too severe a deterrent against entering public service. I think I already explained that. Comment 5. When a lawyer has been employed by one government agency and then moves to a second government agency, it may be appropriate to treat the second agency as another client for purposes of this rule, as when a lawyer is employed by a city and subsequently is employed by a federal agency. However, because the conflict of interest is governed by paragraph D, the latter agency is not required to screen the lawyer as paragraph B requires a law firm to do. Why? Because in a sense, even though it's different organs of government, one is a city and the other is federal, and they are separate levels of government and separate entities, separate sovereigns in a sense. But overall, we think that you are doing public service, right? And so we're less worried about screening you than when you're moving from one firm to the other and they're representing different clients. Okay, comment 6. Paragraphs B and C contemplate a screening arrangement. These paragraphs do not prohibit a lawyer from receiving a salary or partnership share established by prior independent agreement, but that lawyer may not receive compensation directly relating to the lawyer's compensation to the fee in the matter in which the lawyer is disqualified. In other words, and I think I already explained this when we talked about the rule, if you get a set salary, and even if you kind of get a bonus based on, let's say, your hours at the end of the year, fine, that's not going to be affected by this. If the firm has a windfall of fees that they kind of parcel out to everybody, like all of a sudden we have $30 million in fees, and so we're not just going to stick that in the bank, everybody's going to get to buy a new car, except you, right, because you are disqualified. Okay, comment 7. Notice, including a description of the screened lawyer's prior representation and of screening procedures generally employed, generally should be given as soon as practicable after the need for screening becomes apparent. So if you're screening someone, remember, you notify all the parties that this lawyer is here, just so we're being transparent about it, and we are screening the lawyer, and these are the procedures we're following. Comment 8, paragraph C operates only when the lawyer in question has knowledge of the information, which means actual knowledge. It does not operate with respect to information that merely could be imputed to the lawyer. So we don't impute information to former government lawyers. In other words, we want to know, did you access that? And so again, if you're a government lawyer, you're doing pollution enforcement for an environmental agency, a state environmental agency, let's say. And so you have access to information, but also there's other cases going on in your office. And if you wanted to, you could go and get all the dirt on this this company that's doing all this pollution and so forth. But it happens that you didn't, right? You had plenty to do to fill your time with. And so we're only worried about what you actually knew. Comment 9, paragraphs A and D do not prohibit a lawyer from jointly representing a private party in a government agency when doing so is permitted by 1.7 and not otherwise permitted by law. So remember 1.7 is you feel like you think reasonably that you could provide competent representation, and both parties give informed consent. So this is talking about the co-plaintiff or co-defendant situation. What are we talking about? I'll give you two quick examples. One could be a plaintiff situation where let's say you have a county or a small town, and they don't really can't afford to have a whole battalion of lawyers on staff all the time. So sometimes they outsource their litigation to local private attorneys, and you could have a case where there's both a private cause of action and state. So let's say somebody has polluted or damaged a government building and the adjacent property. They could be co-plaintiffs against the person that did the property damage. Conversely, you could have a government agency that has outsourced something. Let's say we have a private prison, or some states have all sorts of things. They privatize their school system. They hire a private for-profit company to run their Department of Motor Vehicles. The FDA hires private for-profit companies to do food testing and safety testing and so forth. And so let's say we have a lawsuit. There's a chance, if we have privatized something, that we might list the government entity as a defendant and the private outsourced party, a contractor that was doing the work for the government. Let's say it could be a private prison, and then the state, let's say. And the same lawyer could represent both, in theory, but you'd have to comply with the conflicts permission rules, exception rules of informed consent confirmed in writing from 1.7. Comment 10. What's a matter? Not what's the matter, but what is a matter for purposes of this rule. In determining whether two particular matters are the same, the lawyer should consider the extent to which they involve the same facts, the same parties, and how much time has elapsed between the two. Here's another review question, and I'm not going to read it out loud because that would be so boring. This is a longer one about 1.11, and what I recommend, you can see on the next slide, I'm going to give you the answer and the explanation. So I want you to read the question and pause the video, read the question, see if you know the answer, and then you can advance the video to the next slide, pause it, and read the explanation.